rise.
My lords, I'm briefly interrupting my learned friend because I need to correct something I said yesterday.
Yes.
We were discussing the copyright injunction, and I submitted to my Lord Justice Arnold that he had held in the Nintendo blocking injunction case considerations such as persuasiveness were applicable under common law principles, and that was wrong. My error, I think, arose for two reasons. First, because I had indeed submitted in that case that that was so, but your lordship's memory was quite correct. That submission doesn't form part of your express reasoning. I provided the Nintendo judgment I was thinking of there. The paragraph in question is 42. But the second reason I think it arose is that there is another Nintendo blocking injunction case. This one had the same judge as in this appeal, Joanna Smith, J, and in that she does reason on the basis that the factors that applied by analogy to section 37 SCA are also those that are found in the European legislation. That case I've also provided. The paragraph is 30. It's right that I should correct the submission, but I say ultimately it devolves down to the point that my Lord Justice Lewison put to me, namely that we rely for the submission on ordinary common law principles. But my apologies for having suggested it was something that Lord Justice Arnold had already said in a judgment. Whether he will do so in future, I don't yet know.
Thank you. Yes, Mr. Birss.
Well, I'm running through essentially chronologically some points that my friend made, that insofar as I think it's useful to reply on them. My learned friend relied on particular points in the judgment where the judge specifically conveyed her own impression. In particular, he showed you a passage in which the judge said she'd reached her own impression of similarity. And we agree there are places where the judge does that. I think the phrase is in common with my own impression. As we'll see, and I'm going to take you through the structure of the judgment as my learned friend invited me to do, to show you where she does this and where she doesn't. But the key issue, of course, on this appeal is whether she approached the question of the price matching message on that basis as a matter of her own judgment, applying objective factors, considering the average consumer, and we will submit that she did not. The next point you made in passing, and whether this was a slip of the tongue or over-enthusiasm, I don't know, but it related to some of the references in the judgment to a low-attention environment. You may recall this.
Yes.
And at one point, my learned friend seemed to be seeking to elide findings that the judge had made about what might happen in a low-attention environment with the in-store situation. Now, the low-attention environment point derived from the H&P survey, and the commentary that the Holland partners had made. And that, of course, was limited to certain advertisements, some of which were on television, others of which were out of home. And the context, in particular, was the out-of-home advertisements, such as posters that you might glance at in the street. And there's a reference there to low-attention environments and particular issues.
Well, I understood Mr. Brandreth fully to accept that comment didn't apply to in-store. But can I understand the relevance of this question? Because as I understand it, and please correct me if I'm wrong, again, this is another one of those scenarios where at trial, neither party invited the judge to make a differential finding with regard to infringement. In other words, to contemplate the possibility that there might be infringement with regard to OOH, for example, but not with regard to usage in store. Both parties adopted an all or nothing position. Have I got that right, or am I wrong?
I wasn't there. I think you may well have it right. Certainly, I don't know whether a specific concession or point was made on either side about that.
Well,
the judge obviously...
My understanding is that Tesco argued that all uses were infringing. You argued that no uses were infringing. Sorry, Lidl argued that all uses were infringing. Tesco argued that no uses were infringing. Neither said party invited the judge to consider the possibility that some types of use might infringe, even if others did not.
I think that probably is right. The only point that I was trying to make in response on this particular point is, of course, it's always open to the judge to look at different contexts of use. And she certainly had lots of evidence about different contexts of use. But the more important point here, which shines through the judgment, is that what one finds in the Hall and Partners survey, for example, in the low attention environments when one's just looking at a marketing poster, is not the kind of confusion which is being relied on in the action. So what's being relied on in the action is the price matching message. And what one finds in the evidence on the low attention environment, which is essentially the Hall and Partners survey, is misattribution. So it's seeing an ad for Tesco and just thinking it's an ad for Lidl. And the judge is very clear in her judgment about the differential or the difference between those two situations and those two different kinds of, generally call them confusion, in paragraph 275, where she says actually likely levels of confusion as to origin are of no probative value when it comes to the actual question of the price matching message. And that, we say, is worth having in mind. My submission on this was merely limited to, because I think that is common ground.
Yeah.
My submission on it was merely limited to my learned friend's vision, as I perceived it, of the low attention environment with what happens in the store.
Sure. Well, as I say, I think Mr. Brandreth acknowledged that, but if he didn't, the point is taken. But I think this is maybe a helpful context to try and tease out a couple of other points, because you rightly there distinguish between, for example, origin confusion on the one hand and the price matching message on the other hand. And of course, the key plank of your argument is all about price matching message, although you have other arguments. But can I just try and contextualise this a little and see if I've understood the overall architecture of the case on trademarks correctly? Because you don't challenge the finding of similarity, correct?
Correct.
You don't challenge the finding of link, correct?
Yes, as in calling to mind, we don't.
Correct. So your challenge is on the two types of injury.
Yes.
And your central proposition is that the judge's finding depends on the price matching message, and that she was in error in that respect. And that's where you bring in this kind of point, which is to say, okay, Hall and Partners, that might be evidence, you would say, of little weight on any view, but at best it might be evidence on similarity, it might be evidence on link, but the one thing it's not is evidence on price matching.
Yeah.
Have I understood you correctly so far?
Yes, and
right.
The judge gets very close to acknowledging that herself.
Yeah. All right. But I want to ask you another question, and it may be better to save it till you come to the relevant point about how this relates to the judge's reasoning on detriment to the distinctive character of the mark, but maybe we can park that till later.
Yes, I mean, we're going to come to, and I'm going to take you through the structure of the judgment, and
Yeah.
that probably is the right point to do it. But there's a point that elides onto that, which my learned friend, and which may be partly what my lord is thinking about. As will be recalled from yesterday, my learned friend spent some time, and I hope I don't mischaracterise it, seeking to set up a different and lesser target than the price matching message to be hit so far as the questions of detriment, unfair advantage, passing off are concerned. And that was the
that's
suggestion.
where we need to distinguish between the cases, because as I understand Lidl's case at the moment, and you may say I'm wrong, but they rely clearly and explicitly upon price matching as the gravamen of their case on unfair advantage and on passing off. But I don't see that so far as detriment, nor do I see that as being key to the judge's reasoning. On the contrary, on detriment to the distinctive character of the trademark, it's a dilution case, and the dilution is what the judge found.
Well, again, I think, yes, it may be we need to look at precisely the way the case is pleaded. But as we understood the way the case is pleaded, and as we still understand the way the case was pleaded, the price matching message was the key point that was set up as being the cause of both unfair advantage and detriment.
But can you explain to me why in your submission there's any logic to that? Because detriment to the distinctive character of the trademark is, generally speaking, a question of dilution. It's lessening the hold of the registered trademark upon the mind of the average consumer.
By way of
so what's price matching got to do with that? I mean, it might make it worse,
well,
but it's not a necessary ingredient.
Well, it might not be a necessary ingredient, but of course, if you establish it, then you have given yourself a nice run on a change of economic behaviour, which is the critical thing you've got to establish so far as the public are concerned. I mean, this is the key point in all these 10-3 cases. Merely bringing to mind is not enough. And as my lord is well aware, what's often said, and wrongly, is, well, bringing to mind always dilutes the hold, because now there are two people out there who cause me to be brought to mind. There's myself when I use my mark, and there's my rival when he uses the similar mark, and that's a form of dilution. And the courts are generally not satisfied with that, partly because you've got to show a change of economic behaviour on the part of the average consumer. And as we read the pleading, it is set up specifically by reference to the price matching message. And we've set this out in our skeleton, our understanding of the case.
Well,
to establish...
we can obviously look at the pleading in a moment, but let's just think about the logic for a moment, because I take your point about economic advantage, and I don't understand Mr. Brandreth contest that. The judge found very specifically that it was not sufficient for Lidl to establish a likelihood of change in economic behaviour. They had to establish an actuality, and that's not challenged, so he stuck with that. And therefore, you say that although she's been correct as to the legal approach, the evidence doesn't sustain the finding that there was a change in economic behaviour, and obviously we will look at that in a moment. But so far as what you more characterise, I think, accurately as the more general case, not specifically of price matching, but of a message about value, as we were discussing yesterday, let it be assumed, for the sake of argument, that use of the signs, the CCP signs, does not convey a message as to price matching, but it does convey a message as to value more generally. Why would that not be legally sufficient for a finding on detriment?
Because one of the big problems that Lidl had in this case is that yellow roundels, as the judge found on more than one occasion in her judgment, are themselves value propositions. They are commonly used for that specific purpose. And one of the problems Lidl faced from the beginning of this case is extremely difficult to fill it out some useful impact on demonstrating value. And furthermore, of course, this is all in the context of a value campaign, where Tesco is saying £2 for this packet of biscuits if you don't have a club card, £1.50 if you do, on the very signs which are complained of. They're then putting them in yellow, which indicates value. So the whole proposition is about value anyway, and that's always going to be the message that the average consumer takes away. The proposition that because you've also called the Lidl mark to mind, there is a value perception. It's immediately apparent that that's extremely difficult to disentangle from the fact that it is a value proposition anyway. You're being told that these biscuits are £1.
Can I just ask a question about that? I mean, I understand the point you're making about what is the message conveyed by the CCP signs in context. But just to avoid misunderstanding, am I right in thinking that you don't challenge the judge's finding that not merely does the trademark with text have a reputation enhanced distinctive character, but also that it is associated in the mind of the average consumer with Lidl being a discounter supermarket offering low prices?
That's what they're known for.
Indeed.
But the difficulty, what I'm trying to elucidate is the sheer difficulty that was faced by Lidl in attempting to run a case, had they done so, based purely on, well, we're generally known as a value proposition. Here you are advertising value, and that itself is detrimental to our distinctive consumer for the reasons that I've given. So in order to overcome that, both in respect of detriment and unfair advantage, they had to make good this price messaging claim, which is why they originally pleaded it. It was quite an unusual case, in fact, but one can see why it was done here, to set up the proposition about the price matching messaging as part of the pleading itself.
Well, can I just ask you about the way Mr. Brandreth puts it in this goes an argument, which may be a convenient way of focusing the debate.
Yeah.
I'm looking at his responsive skeleton argument in tab 26 of Core Bundle at page 529.
Yeah.
And what I'm particularly focusing on is what he says in paragraph 6. And he says this: it is suggested by Tesco that the case was purely about price matching. That was part of it, but not the whole of it. Lidl said that the link generated in association with the value offered by Lidl above and beyond a specific perception of price matching. The judge agreed, and it formed part of her finding of damage by dilution. So he is certainly arguing that price matching, although part of his case, is not the totality of it.
suppose it depends how you read it, but we understand that the case is limited to the case that's pleaded. The case that's pleaded was a case of price matching.
Shall we have a look at the pleading?
Not merely a perception of value.
Shall we have a look at the pleading?
Well, just
The
before,
dilution case is pleaded in paragraph 25 from page 22. Call up A.
Yes. So the case starts on trademark infringement at 22, which is
Yeah, that's clearly,
specifically
that's clearly price matching.
which is the price matching. So we get
yes, so they repeat
So that-
the price
they
matching
repeat it.
allegation, but then they go on to say in B, use of the sign will serve to dilute, and then they say C, detrimental, in that the use of a similar sign to indicate the price is a discount price,
right.
and they say in D, reputation is associated with discounted prices generally, and in consequence purchase Tesco's goods and services being discounted. So the specific plea on altering the economic behaviour of consumers is all about discounted prices generally. It's not about price matching, is it?
Well, if this is a case where, as pleaded, the customers have, as in 22B, come to the belief that these prices have been price matched with Lidl, then it will follow that they will associate the prices as having been discounted, and therefore associate its features with discounted prices generally, and in consequence purchase Tesco's goods and services being discounted. My understanding of that was that the suggestion was this had some kind of wider knock-on effect on the purchase of these goods generally, but the whole thing is founded on the fundamental misapprehension of a price matching campaign as we understood it, because paragraph 22 has been written into these particulars.
Is it a ground of appeal that the judge's finding on detriment wasn't open to her because it wasn't based on the pleaded case?
The ground of appeal as pursued is that the judge's findings across the board were not supported by an appreciation or the proper exercise of the judgment of the court so far as the perception of the average consumer is concerned.
But that's
This
all
is
about
a
price
more
action,
general
because
point.
as I was saying earlier, the key plank of your argument, which we understand very well, is you say price matching was at the core of this,
Yeah.
and you say the judge accepted the price matching allegation. You say the evidence just wasn't there, and that's a very clear argument,
Yes.
which I've got fully on board.
Yes.
But what I'm trying to do at the moment
Yes.
is to tease out how central that question is
Yes.
to the issues. And at the moment, I have no difficulty at all with your argument that it's central on unfair advantage and
Yes.
it's central on passing off.
Right.
Where I have more difficulty in understanding it is why it's central to the allegation of detriment,
Yes.
which first of all seems to be pleaded more generally by reference to, quote, discounted prices generally. And secondly, the judge's reasoning tracks paragraphs B, C and D in the pleading.
I'm sorry, I'm just looking for the passage in the judgment which
gets to this, so it starts at paragraph 158, page 606.
Right.
And your ground of appeal,
Yes.
in relation to detriment, I think is limited to saying that the advertising, the corrective advertising, had nothing to do with the CCP signs.
Well, yes, I mean that's a specific point, but the general point is all-encompassing, and we submit that what the problem the judge had was she had to get to detriment from some case on change of economic behaviour, and that case, as pleaded, was based, we submit, on the price matching, and that was really the only evidence that she could seek to fall back on when it came to change of economic behaviour, and that's what she is seeking to address in 159 and 160. But what she actually does, we submit wrongly, is miss out any step of identifying or establishing a change of economic behaviour. So we assumed that it must be based on the finding of price matching, which she's made earlier in other contexts. Because what she does actually, having set out the difficulty of a change of economic behaviour, is immediately to turn simply to the question of the advertising spend. And that's all she looks at between 160 and 169. And we say that is essentially a bootstraps argument. The fact that a company has spent money on a campaign does not establish the fact that she is required to establish as a matter of law, which is that the average consumer has been caused by the link that they have established with the trademark to change their economic behaviour. And the whole basis of that was that they think a price matching campaign is going on. And she's dealt with that in some detail on the subject, she deals with that in some detail on the subject of unfair advantage. But here, what she's really looking at is purely whether more money has been spent by Lidl as a result of this campaign, rather than looking at the fundamental question that perhaps she could have looked at when Lord Justice Arnold is floating the possibility that the proposition might have been slightly different on detriment, but there's no evidence here that the judge was doing that, always separating out the fundamental cause of a change of economic behaviour between unfair advantage and detriment. I mean,
well, what you're saying is the relevance of the fact that she considers detriment first,
yeah,
finds that that is established, and then she says that at 171, and this is legally correct, of course, that on its own is sufficient.
right.
But prudently, as a first instance judge, she goes on to consider the alternative case on unfair advantage.
Right. Well, what one doesn't, I don't know, to say fairly, but what one doesn't find here, and this underlies, I think, the specific point we've made on this in the grounds of appeal, is any mid-step, as it were, by which the expenditure is linked to an actual change of economic behaviour on part of the consumer. The only point in the judgment that we've seen which might reflect that is in the findings on unfair advantage and some of the earlier statements when we look at it. I'm going to go through the judgment in a bit on the subject of link and when the judge is considering the evidence. There's certainly nothing here, we submit, to indicate that the judge has been through a different process.
What about paragraph 165? In 164, she looks at some of the slides in the price ideas presentation. And then at 165, she says she accepts on balance the genesis of the specific club card campaign against Tesco lay in the concerns Lidl had over the CCP sign.
Right.
And the concern seems to be bottom of page 607. Looks like Tesco are trying to be a bit like us.
Yes, but no. Well, I think in 163, you'll see what was said by the witness as to what the concern was, and you'll see the quote in the last 4 lines. The aim of the campaign was to try and bring back any price issues or misconception of our prices being displayed in the wordless mark at Tesco, which of course is price matching. And that seemed to be the point that was being made, as we understood.
Why is that price matching as opposed to a perception of low prices generally?
Well, if they're Lidl's prices in Tesco's, then that is, as we understand it, the fear of price matching. Which is the fundamental point they raise in paragraph 22 as the perception they say is conveyed by the sign.
So you say, do you, that if we come to the view that the price matching allegation is not borne out, then the detriment case also fails?
Yes. Because we say there's nothing in the judgment to support it other than the price matching when it comes to changes of economic behaviour.
Well, it's her assessment of the reasons why the so-called corrective advertising campaign was launched.
Yes, which we say all comes back to price matching perceptions.
What I'd also forgive me, can I just make sure I'm not misunderstood something?
Yes.
I think you say that the bit on detriment on its own and the fact that there was an advertising campaign isn't actually enough, because the fact that the trader has to do an advertising campaign and spend money doesn't satisfy the test for detriment anyway.
Yes.
You do need to establish a change in economic behaviour. The bit of the judgment on detriment doesn't actually establish a change in economic behaviour in any clear way. But you say, realistically, if you look at the judgment as a whole, there is an establishment of a change in economic behaviour. It's not in that section of the judgment, it's in another place, but it is there and it's price matching.
Yes, there are stray references to it, as we'll see in various bits of the judgment, though the judge doesn't actually have a section where she properly stands back, which she should have done. Yes, that is the point I'm making, and that's the best we can do. And we'd also say if she had been going down a different route here, she would have had to consider how that all worked, given her other findings about the value proposition that was inherently conveyed by these signs in any event, to try and distinguish that impact from some other impact that was being specifically felt by Lidl. And that would have been, in our submission, quite a difficult thing for her to do, but the price matching enabled her to not engage with that difficulty when it came to detriment and indeed unfair advantage. Yes, sorry, I hope that's clarified our position. And that's probably taken some of what I was going to say next. There was I should address my learned friend's reference to the inverted commas in the pleading, for what it's worth. There seemed to be some suggestion that the inverted commas, where it says, or otherwise, I'm making air inverted commas rather ineffectively for the transcript, or otherwise price matching, inverted commas, that might mean something other than selling products at the same or a lower price than the actual price in Lidl. Again, we say that's contrary to the way that price matching was understood by both the parties at trial and the witnesses. I mean, certainly our understanding of that plea is one can see why it says otherwise price matching. It's effectively indicating that price matching is what you've just seen, that is to say, selling at the same or lower price. But of course, if you're not selling, say, the same quantity of goods, one's selling mincemeat in a £1.5 jar and the other's selling a £1 jar, the price might not be literally the same or lower, but you could price match in terms of pounds per pound. But there's certainly no suggestion that price matching can indicate something that's not matching at all. And there was quite a lot of evidence about price matching, which I'm not sure whether your lordships have seen. But Ms Farrand, for example, in supplemental A, she talks about price matching. Pages, that's tab 3, pages 20 to 21. I can't remember whether we looked at that already. She actually distinguishes price matching and price comparison from paragraph 22 on page 20. And the price matching is described in paragraph 24. And it is highly specific, and indeed, as she says in 26, those are things that need to comply with strict rules laid down by the ASA. And then she says in 28, both price comparison and price matching, again distinguishing, can be extremely powerful advertising tools, onerous to do properly with regard to price matching campaigns in particular. Deciding to make your prices at least as low as your competitor is obviously a very serious commitment for a supermarket to make, etc. So it's almost a term of art, it would seem, so far as supermarkets are concerned. And we submit there's no basis for suggesting that the inverted commas give it some vaguer meaning beyond the words which have already been used earlier in the paragraph. Of course, one of the reasons that it mattered was at trial, one of the points that Tesco made was, there's no real worry here because our prices are effectively the same as or better than yours. And one of the reasons the judge rejects that is precisely because when one actually looked at prices, it was clear that they weren't all the same or better. And indeed, Ms Farrant's evidence refers to the fact that Tesco had admitted in the course of the proceedings that they didn't price match to Lidl, and it was for that reason, as she says in footnote to her evidence on page 66 of that bundle, that she doesn't go into any greater detail about it. So the parties were proceeding on the basis that price matching meant same or less, so that when Tesco said that they hadn't engaged in price matching in the action, there was a clear understanding between the parties as to what that meant. Can I now look at the structure of the judgment? I mean, I think I've made some of the points I want to make already, but just to be clear, the judge sets out the law entirely accurately and commendably in paragraph 73. And no one has any issue with what she there sets out. The key passages there for present purposes are the passages on link, which are set out on page 579 of the bundle between paragraphs 12 and 14. And the propositions are, which this court will already understand, the making of a link between a sign and a mark is a necessary part of 10.3. That's paragraph 12. And the fact that for the average consumer the sign would call the mark to mind is tantamount to the existence of such a link. So she's clearly got in mind, rightly, that link simply means calling to mind. And then she goes on to set out the factors, the general factors which the court can look at when deciding whether there is such a link, which are drawn from Intel and are well established. That's in 13, and then explains this is from the perspective of the average consumer in 14. The key point is, as your lordships understand, that's not enough on its own. One's got to go further and show that the strength of the link, to use terminology which I think comes from Intel, is so great that some form of detriment or unfair advantage can be said to be established, and it's for that purpose that we say 22b of the pleading is there. Now, when one looks at the judge's approach to the findings that she has to make, she starts off by doing that in precisely the right way, in our respectful submission. On page 582, she says she has to identify the sign, as we've said. This is from paragraph 75. As we've said, that was an issue in dispute between the parties and is obviously a critical preliminary decision to take before engaging in any further investigation on 10.3. On 584 from paragraph 81, she looks at a reputation, which again is plainly a requirement of being able to take the advantage of the extended protection in 10.3, and she does that perfectly properly. She records that there's common ground, that there's been use of the sign, that's in 85, and she then turns to the question of similarity, which is again a preliminary hurdle that has to be crossed, and compares the marks from that perspective, and comes to, does that perfectly properly in paragraph 91 in our respectful submission. He stands back and approaches the task by reference to the overall impressions created by the mark with text and CCP signs on the mind of the average consumer, remembering they rarely have the chance to make direct comparisons, and again looking at it through the eyes of the average consumer, finds that they would think that the marks were similar. So she duly finds visual similarity, and reports that that was an impression that she formed herself upon seeing the mark with text and CCP sign. So far she's doing that exercise properly on the points that have to be decided, and then turns to 92 and deals with the evidence from a confirmatory point of view. So this is the approach that we say generally is the right approach in trademark cases, and does that job, and then in 95 confirms her conclusion as to a matter of overall impression as of similarity. And it's at this point that she then turns, logically enough, to link, and reports Lidl's submission of a link in the mind of the average consumer, which, as we've already seen, she's identified as being calling to mind, the dispute between them and Tesco's, and then in 98 says she needs to consider the evidence in some detail in order properly to address these conflicting positions, then runs through some of the factors in Intel, but doesn't, on the question of link, do the exercise that she did on similarity and report on her impression standing back, etc. What she does is go on to the subject of confusion, which is one of the issues that, as Miranda points out.
But given you don't challenge the finding or link, why does it matter that she doesn't report her own impression?
It doesn't.
Right.
I'm simply going through the structure of this for present purposes and showing how the judge addressed different issues. Because what one then finds, and we're presently only on link, so she's only looking at this question of calling to mind, and she then turns under this heading confusion to say, further importantly, there's in fact evidence of both origin confusion and price comparison confusion on the part of the public, together with internal recognition by Tesco. And then she talks, first of all, focusing on origin confusion about the Hall and Partners. And that goes on right the way through to the end of 108. And then in 109 we get the Lidl Vox Populi, and she reports that Lidl say I should attach significant weight to it in considering whether the average consumer would make a connection between the CCP signs and the mark with text. So actually she's still there on calling to mind, and appears to be looking at the Vox Populi from that point of view. And runs through the dispute between the parties on Vox Populi. Some of those I dealt with specifically in my opening on the probative value of it, particularly her conclusions at 111. And she finds in 113 they can't readily be dismissed, and makes the findings that I've already spent some time on, and makes the statement in the middle of 113 clearly contains instances of connections being drawn between the CCP signs and the mark text, connections which appear to be prompted by a perception of price matching by Tesco to Lidl, which is not tied to anything particular, but it's a general statement of instances. But again, this is, at the moment, appears to be in the context of calling to mind, but it's simply a statement about some instances in the evidence. I've already addressed you as to why that wasn't correct on the evidence. What one then gets is 114, Tesco pointing out a reasonably circumspect observance consumer will know what store they're in, and that's part of the relevant context. We're still on calling to mind. However, in making this submission, failed to account for the OOH advertising, which is the low attention media, the link to Lidl's reputation as a discount supermarket that members of the Lidl Vox Populi have made for the purpose of Lidl's case. And this is where she makes one of the findings, which is purely on this evidence. It's not necessary for it to establish the average consumer would be confused as to origin, though it appears plain there would be such confusion. Rather that a connection has been made in that consumers think that Tesco's products to which the CCP signs are attached are the same price as the same products when sold at Lidl. The evidence in the Vox Populi appears to me to bear out the making of such a connection. And we say she's essentially there just reporting a conclusion as to what that evidence demonstrates. She's not standing back and drawing a conclusion based on the overall perception of the average consumer. But again, it's slightly confused because we're only now still at the question of link and calling to mind, and she hasn't set out before going into all this analysis the actual legal proposition or proposition of fact as pleaded that this is supposed to go to in terms of unfair advantage and detriment. So it's kind of mixed up.
Because at this stage of her analysis, she's not considering unfair advantage or detriment, as you pointed out.
Yes, but what we don't have is what, in my submission, would have been the appropriate thing to do given the way the case was pleaded, which is a section saying that is the average consumer, in my view, standing back, bearing everything in mind, going to think that this is a price matching exercise.
Well, I take that point, and obviously you made her on that, and as I've said, I understand that, but I'm just trying to see where this goes, because as we've discussed, you don't challenge the proposition on link, and I don't understand that you dispute. I mean, it's irrelevant given you're not challenging the finding on link, but evidence of origin confusion would be capable of supporting a finding on link. You would accept that, I assume.
Yeah.
And if there was evidence of price matching confusion, that equally would be capable of supporting a conclusion on link.
Yes.
So
absolutely.
I appreciate all the points you make about the weight of the evidence.
Yeah.
But in terms of the structure of the analysis here, what's wrong with it?
It's not a complaint about the structure of the analysis here, because if we leap forward, it might be the best thing to do to the ultimate finding on link. She goes through everything and comes to it at 147. That's exactly what she does, but this is only a finding on link. So this is properly a finding. You see the final sentence. The average reasonably observant consumer encountering the CCP signs in the real world at the date of launch would draw a link, and the available evidence amply bears out my conclusion. So she gets to that stage, and appears to have taken the view about an average, reasonable, observant consumer and the calling to mind. But what we don't then get is what we say would have been the right thing to do, given the nature of the allegation in this case, which was to say, is that reasonably observant and average consumer standing back actually going to think that this is a price matching transaction? The fact that there have been a smattering of all sorts of callings to mind, cumulatively, which enable me to say that an average consumer may have it called to mind, obviously isn't enough for that. And she needed to do, as it were, a separate exercise on the specific type of link which was being alleged in this case, we say, which would have made the judgment clearer, would have meant that she actually had to stand back and consider the thing as a whole. And that's partly where we
If I've understood correctly, what you are in effect saying is that the particular link which the average consumer makes between the sign and the mark must be causative of the change in economic behaviour relied upon.
Yes.
So it's not enough, you say, to establish a link in a general sort of way. You have to establish that the particular link is causative of the change in economic behaviour, and the particular link which is relied on in the present case is the price matching allegation.
Yes.
That
is exactly what we say. And the problem here, and one saw it in my own friend's submission, one tends, if one doesn't do that exercise, one just bundles together a whole load of references to Lidl every time anyone mentions Lidl when one sees the sign.
Well, it's partly a problem of chopping up cause of action into discrete elements without, if you'll pardon the expression, maintaining the link between them.
Yes, yes. And this was the critical point that the judge should have had in mind throughout. Ultimately, she was going to have to get to this basic proposition. Is the average consumer going to see it as a price match campaign with Lidl or not? That really was the big fact she had to decide. And the fact that we're scrabbling around trying to find where she has determined that and whether it's actually just a statement about the evidence, which in my submission it's found in various odd statements about the evidence, actually raises the precise problem with the judgment. And clearly, when it came to some of the other issues, the judge approached the matter perfectly properly in terms of similarity and indeed in terms of the overall link. But we were missing that vital step in the reasoning in our submission. And that is then when one gets to intention, which we've looked at, I think, already, and then detriment, which I looked at with my Lord Justice Arnold, where she doesn't make the finding that's necessary, we submit, for the change in economic behaviour, and one only gets to that under the heading of unfair advantage. And there we say plainly, on the pleading on any view, this was what my learned friend had to establish, the price matching message. And the judge doesn't actually ever in this section stand back and make the finding that the average consumer, clothed with the characteristics one has to expect from the average consumer, in her view, standing back, would change their economic behaviour due to this particular message which they had drawn from the mark.
Can I just ask you about the reasoning in this part? Because at the moment it seems to me that the key paragraph is 174, because, and you made the point in your opening of the appeal that she starts by saying, against the background of my findings so far in my judgment, and I've got that point on board. But what she goes on to say is that due to the resemblance of the CCP signs and the Lidl marks, Tesco has taken unfair advantage of the distinctive reputation which resides in the Lidl marks for low price brackets discounted value. That's the objective fact of the creation of the link. So she's undoubtedly looking at causation there, is she not?
Yes, but she doesn't actually then there address what link and how that has been caused. And what one has to look further on to see quite what she's saying. And she does then move on to talk about quite a lot of things. She finds, obviously, in 176, the CCP signs were intended to convey value. Well, there's no doubt about that. For all the reasons that I've given, they did convey value entirely independently. And then 177, which is what my learned friend likes, but of course the problem there is that she doesn't address specifically the pleaded message in the first sentence, but then gives, by way of example, the evidence of a single witness, Mr. Paulson, that he had interpreted the CCP sign as guaranteeing the same prices as Lidl. That was the answer he gave to the judge's own question. Now, actually, what she was being asked to find an unfair advantage was whether that was the response of the average consumer, not simply the response of one witness. And plainly, as I think my friend agrees, one witness can't possibly stand for the average consumer. And then all we get after that, we then get her addressing this point about whether Tesco's prices are actually cheaper or not. And then we get the passage that you've been asked to look at, and that I asked you to look at in paragraph 180, which is, as Lidl points out, the immediate problem caused by the link is that consumers think they do not need to check if they can get a particular product in question cheaper at Lidl, because Tesco have already checked. Now again, she hasn't made a finding about the average consumer getting that price message, applying, standing back and looking at all the characteristics of the average consumer. It's difficult to know where that comes from. I mean, we would say it can only come from perhaps some of the consumers that she's looked at in the context of Vox Populi, conceivably Mr. Paulson, but certainly there's no suggestion here she's standing back and looking at the question as, in our respectful submission, she should have done. And then she says that there's a longer term consequence of the value perception being improved, which of course was not the pleaded case anyway. So that's as far as it goes there. And then I think that's the end of it really, so far as the trademark analysis is concerned. When she gets to passing off, once again, she falls back on what's said to be the effect of the evidence, and the evidence being consistent. That's 272 and 274. But of course, as one friend accepts, these two cases stand or fall together. So our basic point is that because this primary issue has not been addressed separately, the judge got into a bit of a mess, if I can put it that way, with her assessment of the average consumer. She should have stood back and asked the question, the brutal questions that we ask in our grounds of appeal in our skeleton argument, which would, we submit, have led to the conclusion that drawing that kind of conclusion from this particular sign is speculative, irrational, and simply not consistent with the behaviour of somebody exercising ordinary caution or circumspection, and should have been dismissed on that basis. The fact that you can find instances where people say that they might think that, or you might interpret the odd message without seeing the witness in such a way, doesn't answer the question. And really all the judge ever does is to look at individual instances without asking herself whether on this point they can be extrapolated out to the average consumer.
Can I just ask about passing off? The passing off case is based very squarely on the allegation that the misrepresentation was a price match.
Yes.
So if it was agreed, as I think we have been told, that the trademark infringement and passing off stood or fell together, that would only make sense if the trademark infringement case was also based on exactly the same allegation.
Well, I don't think that was how it was put below, was it? It's how it seems to be. That's my shorthand for what's said in the skeleton arguments on appeal.
Yes.
Was it put that way below?
Can't say. It's certainly the way that certainly what's been conceded on this appeal. And
well, to be clear, you didn't offer any separate argument on passing off because, as I understood it, you accepted if you failed on trademark infringement, you would necessarily fail on passing off. And Mr. Brandreth took the same course.
Yes. Because, and that only works as a matter of logic, we would submit, if in fact the price matching point is central to both causes of action as perceived by the parties on
yes,
this
but
appeal.
I don't think Mr. Brandreth accepted the converse proposition, namely that if he failed on passing off, he could not succeed on trademark infringement.
Well, I think we're probably trying to construe the statement standoff altogether or whatever it was.
That was my. I didn't.
Right.
I didn't think Mr. Brandreth used that expression. That was my shorthand.
Oh, okay. Well, we would submit that my Lord Justice Lewison is comment there is correct, that what's going on here has always been clear, which is that this case was presented about price matching. It is about price matching. That's the only case that makes sense on passing off, and it's the only case that was advanced and makes sense so far as trademark infringement is concerned from either point of view, and there is no independent basis in the judgment for a finding of trademark infringement on the issue of detriment for the reasons I explored with my Lord Justice Arnold a little earlier on. I think that simply leaves the evidential findings. I wasn't going to spend very long on that. My learned friend didn't really spend very long on it, leaving you with his submissions as made in his skeleton argument, which I hope to pick up when I open the appeal. So far as the Vox Pop is concerned, again, he seemed to want to downgrade that evidence and the reliance on it by the judge. And I've said, well, we say, in the end, it seems to be almost the only thing the judge had to go on, or thought she had to go on. His submission was that the judge was actually using it simply to test particular propositions within the context of the question of link. Well, of course, if that is in fact all she was doing with it, then there is no point in which one can extrapolate out from these findings to something that would support unfair advantage or detriment or passing off. But it's only against that background that, to quote him, he says, once you understand that she's doing that, then her reasoning becomes entirely comprehensible. Well, we say this is one of the problems with the way this judgment has been approached by the judge, that buried in this section, which indeed is in the section on link, one has stray statements about price matching. Paulson and Berridge, my learned friend contends the judge didn't treat them as the average consumer. He says, and I think he accepts, that would, of course, have been an error of principle. I'd only say that's there's a slight oddity in that, in that the judge actually considers what they say at 120 of the judgment, which is on 594. And oddly criticises these witnesses, first of all, as you see in the second sentence, criticises the approach of Tesco to the witnesses, first of all on the basis that it wasn't suggested to either of them that he was confusing Lidl with Aldi. Well, of course, these were the people who were offended by the blue and yellow. And one of them had actually contacted Lidl. He was the one who'd had a trademark dispute with them. The other one posted the Lidl logo on his Twitter feed. Is that the right phrase? Now, it was never part of anyone's case that these witnesses confused Lidl with Aldi. The point was that they weren't mentioning price matching. But then it says, or that he was more suspicious than the average consumer, which would have been an odd line in cross-examination to invite the witness to speculate about whether they were more suspicious than the average consumer. So whether the judge
goes on to say, Mr. Cuddigan did not seek to identify any grounds, whether in cross-examination or in submissions, on which Mr. Paulson or Mr. Berry should be regarded as outliers.
Right.
When it came to considering the perceptions of the reasonably observant average consumer, she makes a similar point of 274 in the context of passing off.
Yes. So
weren't said to be atypical. Now, is that correct or is that wrong?
I haven't got the I haven't got the actual submissions that were made about them to hand. My learned friend says, yes, I have, they're in the bundle, but that doesn't actually help me very much in bringing them to hand at this particular moment. He then makes some more comments. The point about Paulson and Berridge being outliers, in our submission, it isn't a burden on a defendant in a case like this to prove that somebody is somehow an outlier. I mean, the submissions I made in opening.
Well, let's use the expression she used in 274. Atypical. It's an easy submission for counsel to make.
Right.
That Messrs. Paulson and Berridge evidence doesn't help her because they're atypical,
well,
and yet that submission doesn't appear to have been made.
Well, plainly, it was an inherent part of Tesco's case. If you believed that Mr. Paulson actually believed that, as he said to the judge ultimately, that he thought there might have been some price matching, that he was, that if he believed that, plainly it was Tesco's case that was not typical. Tesco's whole case was that isn't the response of an average consumer applying ordinary caution. It's not necessary in our submission to make individualised submissions about two witnesses who've come along out of the 10 million, or however many it is, who've been exposed to these signs. One never knows whether one or two individuals are, whatever typical means, typical of the average consumer. They are what they are, but that's why the courts are consistent that one or two people can't stand proxy for the average consumer, and that, I suppose, was why my learned friend was saying the judge didn't say that these people were in fact.
The submission was a little different. I'd be interested in your response to it. What he submitted, as I understood it, was that the mistake that the judge might have made but did not make was to treat their evidence as determinative of the ultimate question. So, in other words, she took it as a data point, and not as deciding the case for her. Whereas, if she had taken it as deciding the case for her, he accepts that would have been a plain mistake.
In truth, she looks at these witnesses on the question of calling to mind. These were witnesses who'd complained bitterly about the blue and yellow. They weren't witnesses who had changed their economic behaviour, so it was never going to help my learned friend anyway to suggest they were behaving like average consumers. We would submit plainly they were really of little assistance to the judge at all, apart possibly from the question of calling to mind. I mean, that is as far as she could possibly have taken it. They gave her nothing in our submission so far as the rest of the case was concerned, whether or not one considered that they were in some way average. I mean, Mr. Berridge's confusion, you'll recall, was instantaneous and only lasted for a few moments while he did what he described as a comedy double take when he looked at the website. I'm just being shown my learned friend's closing from trial. Yes, in fact, I think my learned friend, Mr. Cuddigan, is being traduced somewhat here, because actually he did. In paragraph 117, paragraph 118 of his closing, which is at tab 33 of sub C. Paragraph 117 to 18, that's on page 765. I'll just ask your lordships to read those two paragraphs, but we submit that was the case before the court. And it's correct. Source survey, again, Mr. Brandreth didn't seek to say it had any quantitative value. We didn't hear from any witness, obviously, from the survey, and the judge only relied on it as establishing calling to mind. I don't think I need to go further with that. My lords, I think we have my overall submissions in reply to my learned friend's case. We've explored them again in some depth this morning, and unless I could help you further, that was all I was going to say on the case on trademark infringement and passing off. Grateful.
My lords, there were two striking characteristics of my learned friend Mr. Brandreth's oral response to the copyright appeal. First, he seemed to want to rewrite the judgment in wording that he perhaps felt could be defended, and not to actually stand up for what the judge's reasoning said, and that was surely because the reasoning was not defensible on the basis of the law as it was presented to the trial judge, as I will show you. And this shows an approach also somewhat runs into the mud in the absence of any respondent's notice, because the argument he presented to the court wasn't before the judge, wasn't considered by the judge. Second, he declined to offer any defence whatsoever in respect to the legal approach the judge took to infringement, which approach was plainly contrary to principle. I have 8 points on copyright. Bear with me, the first is very much the longest. They get very much shorter. The first is the big subsistence issue of principle, and that was, could Lidl rely on creative choices made by the stage 2 author in support of their claim? At trial, Lidl relied on all parts of the stage 3 logo, the mark with text, without distinction. Their case was straightforward. They said the stage 3 work is a combination of elements, and copyright can subsist in combinations. Look at Ladbroke and Hill. And so that my analysis, which was based on who actually did what and when, they said was of no relevance. They derided it in their closing submissions as the fallacy of division. That's supplemental 3, tab 32, page 723. To be clear, my lords, in accordance with that case, they told the judge that she did not need to distinguish in any way between what was done by the stage 2 author and what was done by the stage 3 author. So that is where the battle lines were drawn, and on this issue of law, the judge sided with Lidl. She rejected our proposition in terms. If we could go back to the judgment, please. And I'll start where my learned friend started, in paragraph 285, where the judge recorded the development story given by Mr. Unterhalter. Now, my learned friend said it would be surprising if, having set this out, the judge then disregarded it in her later reasoning. And his argument was that, oh, well, she plainly had it in mind when it came to paragraph 289. The plan, the strategy, is to soften the judge's approach to division, the fallacy of division. I suggest a rather more obvious explanation for the existence of this passage is that it is because it is foundational to the key dispute of principle which the judge addressed in the very next paragraph. So paragraph 286, Tesco contends the Lidl logos were developed over some 20 years in 3 distinct stages. They incorporate elements in the form of the blue square and yellow circle created by different authors, such that there is no principled basis to consider the skill and labour involved in the design of those elements per se together in one copyright work. My lords, that proposition was rejected. In accordance with my learned friend's urgings, that was said to be the fallacy of division. The judge goes on, Tesco says that none of the skill and labour involved in producing the stylised Lidl text logo can be protected by the design of the circle logo, and that similarly, none of the skill and labour involved in producing the stylised text logo or the circle logo can be protected by the addition of the blue square in the mark with text. Rejected. And that is the context for everything which followed in the judgment.
It's that last sentence which was your key point, isn't it?
Well, I think it's probably more accurate, more accurately in the first passage, but they're both the same. It's the question of division. Can you give the stage 3 author credit for decisions, choices made by the stage 2 author? My learned friend said, absolutely you can. This is a combination. You wave your magic combination wand and the distinction vanishes. I said, no, it's wrong as a matter of principle. And the judge sided with him. Was she right to do so? Absolutely not. The judge's decision conflicts in terms with 2 authorities of this court, with Martin and Cogan and Dix and Brooks. You will recall the words of Lord Justice Floyd in the context of derivative works. The second author may be entitled to copyright in the resultant work, but it will be a work of sole authorship, the originality of which could only lie in the contribution made by the second author.
Well, that's why I think your last sentence is the key point.
Well, there we maybe so, my lord. It is common ground that we are dealing with a derivative work here. I showed you the passage in my learned friend's skeleton expressly denying a continuum of development.
But can I ask you about what the judge says in 289? Because the reasoning in 289 seems to be different to what you are submitting. Because what she says is someone in the employ of Lidl took the Lidl text and the yellow circle with red borders, so that's the stage 2 word,
Yes.
and superimposed them on a blue background to create the mark with text. And she says, I consider that this is likely to involve time limit creative freedom. So her decision appears to be based upon the creativity involved in the act of superimposition.
Right. So there are several answers to that, but the main one, the reason my learned friend dwelled so much and put so much weight on that paragraph, that passage, is because it's an outlier. It's the only one that admits of that exculpatory explanation. But if you see it in the context of the whole judgment, and I'm going to show you the other passages.
Is this an outline? What about 288, the first sentence? The act of bringing together the little text and the yellow circle and the blue background.
Right, but my lord, with respect, read on. The combination of colours and shapes and the orientation of the various elements.
To be sure.
That is going on any view beyond the work done by the stage 3 author. But
Why?
more importantly,
because the stage 3 author has put in a square, that's a shape.
yes,
Put in a
plural
colour, the
shapes.
blue, the orientation, which is what you describe as the ratio.
Plural shapes, plural colours. Orientation of various elements. No, there was a single shape, a single colour, a single element. And there's more, but more importantly, if that was all that the judge was doing, taking the marginal contribution of the stage 3 author, why is she rejecting the proposition? I reject Tesco's case. There's utility in that rejection because she is acceding to my learned friend's submissions about the fallacy of division. And what you're putting to me is that she hasn't subscribed to that rejection, that she's denied it. She's agreed with my position on the law and therefore only considered the stage 3 author's contribution. My lord, that is not the correct way with respect to read this judgment. She's decided the point of principle wrongly, and indeed in a manner which my learned friend, as I will explain shortly, hasn't even defended. And that must inform what follows.
Can I ask a different question, which is a slightly more elementary one? I probably should have asked Mr. Brandreth this. She says in the beginning of 288, she rejects Tesco's case for 2 main reasons.
Yes.
And the first one is combination of elements, and that's what you're majoring on the moment.
Yes.
I understand that argument. I'm struggling to identify explicitly where she identifies the second reason.
6 lines down in 288. However, as to that, my second reason...
Well, exactly. Yes, sorry, thank you. That was what I was struggling to find at the moment.
And I will come back
And
to
that then goes on into 289.
And I'll come back to that if I may. My lords, because the judge got this issue wrong, her whole analysis of subsistence and infringement must be set aside, because she has, in respect of both issues, considered the wrong creative decisions and the wrong work, a mistake which could hardly be more fundamental. What then was Lidl's response in relation to this error? Did they seek to distinguish these authorities? No. They submitted to this court that the judge was embracing a different argument, one that is not actually mentioned in her judgment and which was not actually run at first instance. My learned friend began by somewhat mischaracterising the main issue. He said, and I'm quoting from the transcript, the error of principle that is said to have occurred here is that the judge took into account in her assessment of the created effort matters that could not possibly be part of the work that was relied on. That is an overgeneralisation, and by making a broader generalisation of the issue, my learned friend allowed himself to smuggle in a different answer, The answer, which the judge recorded in terms, was about the creative choices made by the wrong person. But having generalised out in this way, my learned friend's defence of the judgment is, we say that there is a creative choice in deciding, when creating a new design, to take the yellow circle and reuse it in the mark with text. My lords, that is a different point. That is the I create when I select parts of another work point, and I will come back to that. But it is not the point of principle that was before the judge, which was about the creative choices actually done, in fact, by the stage 2 author. Paragraph 286, our argument. As to that, my learned friend offered no defence. So when my Lord Justice Arnold asked, what is the relevance in your submission of the fact that the stage 2 logo was not in the public domain, it is a copyright work owned by Lidl, but by a different author at a different time with different creativity, pausing there, the point of principle, and the judge held they could rely on all of that. Now he said, my lord, my response to the appeal is based on what I pleaded, which was the third work, and I do not rely on the second work in and of itself. So it is only relied on now to the extent that it has been selected for inclusion by the stage 3 author. My propositions of law are no longer in dispute. He offered no dispute on these points of principle, and we invite you to follow the prior cases in this court which were contrary to the judge's decision. Now, there was a further confirmation, that answer, was of course a further confirmation that we are here truly concerned with a derivative work, because my learned friend distinguished himself between stage 3, at which he pleaded, and stage 2, which he didn't. Now I'm coming back now to my Lord Justice Arnold's question, following this through in the judgment, and my learned friend's repeated referral to paragraph 289 as if it were representative. It is, we say, an outlier as a matter of logic and substance. He likes it because it says someone in the employee of Lidl took the Lidl text and yellow circle with the red border and superimposed them on a blue background to create the marbled text. And that is indeed the most defensible statement the judge made on what the stage 3 author did, because it acknowledges that the yellow circle with red border was pre-existing. The problem is that the judge clearly weighed those stage 3 creative decisions in her assessment. We know that she was going to do that because she rejected our case on the main point of principle. In so doing, she held that it was proper to take account of the skill and labour involved in the design of those elements per se together in one copyright work. So of course she went on to do it. But later in the same paragraph she referred to basic shapes and colours. In paragraph 288 she referred to the combination of colours and shapes and the orientation of the various elements. In paragraph 290 she referred to a combination of simple shapes and text. What is text doing there? It is only consistent with the rejection of the point of principle, and it is wrong in principle. 291, she referred to a combination of text, colours and shapes, and most damningly, in paragraph 299, in the context of infringement and substantial part, she held that the blue background with the yellow circle plainly forms a substantial part of the mark with text. There can be no doubt that in that passage, the judge is not treating the yellow circle any differently from the blue square. The tariff applied to copying the creative decision of the stage 2 author.
I'm sorry, can you help me? Because at first blush, it seems to me this is a paragraph about copying.
No, what the judge did, my lord, was deal with substantial part first and then deal with copy. So she started in paragraph 299, that's the only place she deals with substantial part. So she then goes on to decide whether that has been copied from the mark, from the work. So you see, if you turn forward, copying copying ends at 315. There's no separate consideration of substantial part. It's all in paragraph 299.
Yes, okay, that's helpful, thank you. But Mr. Brander's response to that, I think, if I remember rightly, was he said that the explanation for that was that there was barely any separate argument before the judge on the question of substantial part. He said there was only a paragraph in your submissions.
Well, my Lord, yes, because this part of the argument reflects what I said about subsistence. Once you've rejected my case on subsistence, and you can rely on the yellow circle, it follows that it's in here. So the two arguments stood or fell together. What I'm relying on paragraph 299 for, before this court, is because it is a clear demonstration of the judge's decision on the point of principle. The yellow circle cannot be there. It shouldn't be there on any basis. But even on my learned friend's argument, it should only be there on a selection from prior work basis, which cannot have the same creative significance as coming up with the idea in the first place. In the law of copyright, copying something isn't the same as creating it. If it were, the law wouldn't exist. And yet the judge has approached it on that basis. Those are my submissions on the main point, the point of principle. The second point is my learned friend's fallback, the retrofit, creative choice of a starting point. I've already explained how reproducing someone else's work involves no origination, no creation, and has zero weight for the purposes of subsistence. I've already explained how that proposition was stated in terms, was supported at least by Lord Justice Floyd, when he said that originality could only lie in the contribution of the second author. Until something has been added, something has been changed, there is no contribution. My learned friend didn't refer to Lord Justice Floyd's reasoning, but he did boldly state that the contrary was good law. He said, and I quote, "At the beginning, when one has a blank page, the decision as to whether or not to incorporate something else at all pre-existing is itself a creative choice." In other words, before you have made any contribution to a pre-existing work, you have done creation.
So just going back to the diagram that you put in your skeleton argument,
Yes,
if you picked a different round painting
yes,
other than Caravaggio,
yes.
the consequences for copyright would be the same, you say?
I say,
It doesn't matter whether you pick Ford Mannix Brown's Last of England or Caravaggio's Medusa or Michelangelo Tondo, it would all be the same.
right. So my case is, once you decide to appropriate someone else's work entirely, you put it on your computer, you put it on your canvas, you have done nothing creative. Inherently, all has been copied. You have originated nothing. And that is axiomatic in the law of copyright. Because if it were otherwise, you could never have an identical copy. Your decision to copy someone else's work would be considered to have creative weight, which is, with respect to nonsense. My learned friend says, no, the options before you mean that merely by selecting someone else's work to reproduce perfectly, without any change, you've done something creative. And he has to say that, because of course that's the only way you can get any reference to yellow circles into the copyright case, because that's what's happened. And this is what I call a retrofit, because the judge has never considered this argument. Nowhere in the judgment, and there's no respondent's notice. It's bad in law, but it's wrong on the facts too, because in order to advance it, my learned friend somewhat glossed the facts. He indicated there was a sort of selective filter being applied. I look at the prior work, I decide what I want and what I don't want, and that act of selection was somehow creative. He said there is a creative choice in deciding, when creating a new design, to take the yellow circle and reuse it in the mark with text. But my lords, that wasn't the evidence. The evidence that there was that there was a blue square that was added to everything that was already there. The stage 3 author didn't simply select the yellow circle. They took the yellow circle, the red ring, the text. They took everything. There was no choice over what to take and what to discard. Wholesale reproduction without alteration was the starting point. Wholesale reproduction means no choices, no origination. And we are again foursquare within Martin and Kogan. What is the contribution of the stage 3 author? It is the blue square alone. The third point, my learned friend advanced a case based on the idea of creativity in what is rejected. A new point, not before the judge, no respondent's notice. He referred to shapes and stripes and shades and said that these were all rejected when the stage 3 author chose a block primary colour, and that these choices to reject should be recognised as creative for the purposes of subsistence. But as my Lord Justice Birss pointed out, this is a question of fact. Brevity and simplicity can be the result of skillful creative work, but they can also indicate an absence of work. John Cage composed 4 minutes and 33 seconds and may well have had a musical copyright in a work that's entirely silent. But if there's a long pause in my submissions because I can't think of what to say next, I'm not creating something. And on this question, my learned friend has no evidence. He has no evidence that stage 3, we worked through different shades, we worked through different spots and stripes, and then after a long selection procedure and heated debate amongst the design consultancy, we decided, let's keep it simple. This is not an Exxon case. The fourth point, skill and labour and the wrong standard. This was the second reason the judge gave for rejecting the point of principle. I explained that it's not as a matter of logic, a reason for rejecting that point of principle, but I also raised in my grounds of appeal the fact that it was wrong to rely on Caro Step and Solar Thompson because they apply a lower tariff, a lower threshold, so they're no guide to the higher threshold. My learned friend literally did not answer that point. The fifth point, reliance on Tesco evidence for the purposes of creative choices. Paragraph 11 of our grounds of appeal. This was my Annie Leibowitz point. You can't rely on Diane Albus's approach to portrait photography in relation to a photo booth. Literally no answer to the point. 6, presumptions of originality. Section 104.5 of the Copyright Act states, if the author of the work is dead or the identity of the author cannot be ascertained by reasonable inquiry, it shall be presumed, in the absence of evidence to the contrary, that the work is an original work. My Lord, in that context, original means not copied. And here, the contrary was common ground. Lidl led evidence that the stage 3 work was copied from the stage 2 work.
Sorry, can I be clear as to the legal argument? I understand the factual argument, but is it your submission that the word original in section 104 has a different meaning to its meaning in section 1?
It means that it has not been copied. It doesn't. There isn't a presumption.
So you are submitting that it has a different meaning.
That it's I'm not submitting that it has a different meaning. No, it means that right. They are obverse sides of the same coin. Pure copying means no skill, no independent skill and labour. The seventh point I've touched on already, but we need to go back to it in the context of infringement because it's fundamental. Paragraph 299, and the yellow circle being accorded the same weight as the blue square, again, that approach is indefensible, and my Lord Justice Birss put the question to my learned friend in the context of subsistence, saying that there was a danger that the judgment appears to give equal weight to the stage 2 work and to the blue square. My learned friend fell back on paragraph 289, which I call the outlier, but that answer isn't available to him in relation to infringement. In relation to paragraph 299, the judge's position is stark. It's not that there's a danger of that happening. That is what she did. And that is, of course, entirely consistent with her rejection of my argument on the point of principle. She is, in effect, giving me credit for Caravaggio's snakes in my written argument. My learned friend had no response to that point whatsoever. The final point in relation to copyright, my learned friend repeatedly asserted that everything was taken from the mark with text in Tesco's sign. You will recall in opening the appeal on copyright, I relied on the fact that the shade of blue was different and that the ratio is different. And when pressed on the latter, my learned friend sought refuge in the proposition that the argument wasn't taken before the judge. No one sought to distinguish it. There's a very good reason for that. That at trial, Lidl never told the judge that these two matters were relevant to subsistence. They never relied on the shade of blue. They never relied on the ratio. Those points were taken for the first time in my learned friend's skeleton argument before this court, and again, there's no respondent's notice. Now, when we saw them, we didn't object because the observations obviously help us on infringement. But you can't have it both ways. According to his oral submissions, he's free to raise new points on subsistence without a respondent's notice, but I cannot adopt them on infringement. That approach is a paradigm of procedural unfairness, and you must reject it. Either his position is weaker on subsistence, no shade of blue, no ratio, or it is weaker on infringement. My Lords, unless you have any questions in relation to that appeal, I was going to move on shortly to the injunction.
Yes.
There were two grounds of appeal in relation to the injunction. The first is the hypothetical that the judge ought to have approached the decision in relation to. My learned friend posited an alternative hypothetical, one in which there was no actionable trademark infringement or passing off claim, but where Lidl nonetheless owned a valuable goodwill.
No, he expressly disclaimed goodwill. He said reputation.
Sorry, you're right. A valuable reputation, but no formal goodwill because of no customers within the jurisdiction. Another argument not put before the judge and not embraced by the judge. The argument works by inferring. What's really going on here is it allows him to infer that there would be significant benefit to Tesco from that reputation, and indeed damage to Lidl from Tesco's use of the signs, but that was not actionable. Very difficult to see how that could possibly be the outcome of success on the trademark infringement or passing off appeals. My learned friend did not suggest how it could be. I don't really need to invite you to reject it, because in the event that my learned friend Mr. Purvis has succeeded on his appeals, I can simply ask you to consider whether that reflects the basis of his success. The only other argument on this ground was the same point in a different guise. He said that the notional negotiation should take account of the motivation regarding obtaining cut-through messaging on the part of Tesco. And that amounts to an argument that the notional negotiators are under a misconception about the benefit of the licence in issue. That Tesco would get the benefit of that, the benefit of that advantage. Sorry, that Tesco would be willing to pay for the benefit of that advantage, even though it wouldn't manifest.
Even though it wouldn't what?
Wouldn't manifest. That's at odds with the very purpose of negotiating damages, which is to value the actual benefit, an objective value of the actual benefit. Because, again, if the trademark and passing off claims fail, then there isn't going to be some sort of messaging benefit in using the copyright work. The second ground, my learned friend's argument on the alternatives, the lawful alternative signs, rested on the fact that Tesco had chosen the sign that they did over the yellow tile, the merely yellow square, that was amongst the other signs tested by the source. And he said that because the yellow tile was not chosen by Tesco, these alternatives must be rejected. That makes no sense to us. Firstly, as to the context, as the judgment makes clear, Tesco didn't know about the copying which took place.
Well, is that right?
They gave instructions to look at value, and that caused Wolf Ollins to if you turn to page 314 of the judgment, I think it's fair summary of the position.
So which paragraph?
Paragraph 314.
Yeah. Can I just ask a question just to clarify my own mind? For the purposes of the argument about damages versus injunction,
Yes.
what is the infringement that we are considering?
Well, obviously that is an output of my lord's decision on.
But for the
copyright.
purpose of your argument,
Well-
are we are assuming, are we the infringement as found by the judge?
No. I think it has to be. I mean, although we're taking these together for convenience, this argument, this appeal relates to the relief hearing in front of the judge, and it follows on from her conclusions about copyright infringement. If you came to the decision that she took too broad a view on the work in issue, then that exercise has to be redone.
Yes.
Because plainly there is considerably less in just a blue square.
Well, I follow that.
Right, so it's 50%.
But I think your argument is, even if she was right
My lord is absolutely right. It is
to
even
find
if
the
she's
infringement that she did,
Yes.
she was still wrong
right.
to grant the injunction.
Precisely. Which
So I think the answer to my question is, for the purpose of this part of your appeal, we are assuming the infringement as found by the judge.
yes, but subject to this proviso. You could be with me on the main appeal. You could decide that it's just a blue square, but that it's infringed. In which case,
So in other words, we would be against you on we would be against you on
on either of them, I suspect.
But we would accept the argument on infringement to the extent of accepting that the decision need to be remade, but coming to the same ultimate conclusion.
Yes, I mean, I think there are a number of different paths through to it. So you could be with me on subsistence.
Because if there's no subsistence, then
Sorry.
there can't be any infringement.
You could be with me on the principle of subsistence, that the stage 3 author only gets a blue box, and you could hold that is infringed.
Yeah.
Right?
So that would be a more limited finding of infringement.
Indeed. I think any success gets a more limited infringement, probably down to just a blue box, in which case the arguments on the injunction apply a fortiori, all of them.
Well,
because
but
when I'm
isn't
further
the point
away,
of my lord's question that if we came to the conclusion that there was limited degree of subsistence and limited infringement, then that in itself falsifies the basis of the judge's conclusion
my lord, yes.
on when it comes to the injunction. But what do we then do?
We would invite you to exercise your own discretion in accordance with the principles,
Rather
the
than
arguments
remitting
before. That is an alternative. I think in the circumstances, we would prefer a decision from this court, but I don't think we have a strong preference either way, and if you consider that's a preferable procedure, then of course that's what you should do. But there are moving parts as between the two appeals, of course.
Yeah, but your argument is even taking Lidl's case on copyright infringement at its highest,
Yes,
the judge was wrong.
precisely, which is why, my lord, I refer to these third-party images, which contain both the blue square and the yellow circle, because that is taking the case at its highest, because those are the only two commonalities.
Yeah.
As a matter of fact, of course, Tesco didn't know about these third-party alternatives because they didn't know about the copying. But the law requires consideration of them now. The notional negotiators are taken to be aware of them. It doesn't have to be the parties at the time. They were there. They are available in relation to the injunction. And my learned friend simply hasn't stated a case in relation to them. He says they're not precisely equivalent to the mark with text. But so far as material, the third one was, the one that I simplified and abbreviated, it was the same. And of course, if one's constrained to just the blue background, they're all pretty remarkably close. But my lords, even if you allow for some differences, they're still highly material. You have, on the one hand, an alternative design that is essentially free. What are the notional negotiators rationally going to pay for the right to use the mark with text? If Lidl's notional negotiators demand an order of magnitude higher than the $40, well, pretty soon they're just going to say, oh, we'll go for this one. The difference isn't worth it. So it's still highly constraining on the rational response in that negotiation. And these numbers are all orders of magnitude less than the £7 million that the judge held it would cost to rebrand. As to reliance on other factors, we accept that the judge did rely on other factors, but it's absolutely clear from the judgment the main event was the valuation of damage, paragraphs 20 to 33. If that was wrong in principle, then the judgment is vitiated. Lastly, dissuasion. We're not clear that this argument was open to my learned friend, but it's bad anyway. Firstly, on the offers, there's nothing reprehensible about rejecting offers in the context of a massive rebrand cost in the face of a right that may be worth £100 or so. It's not to be criticised, and there's no need for dissuasion when the copying took place without the knowledge of Tesco. I remind you again of paragraph 314 of the judgment. My lords, unless I can help you further, those are my submissions on the copyright injunction appeal.
Thank you, Mr. Tulliam. Yes, Mr. Brandreth, we're on to your cross appeal now.
Yes, my lords, we come to the appeal on bad faith. And on this issue, which is of great importance to my client, we begin by accepting that, of course, it has no bearing on the main judgment, the liability of Tesco. And we say, perhaps for that reason, the judge here, even as Homer did, stumbled. My client had relied upon a 1995 registration for the Wordless Mark. And that was said to have been a bad faith registration because it was a defensive registration. That is to say, it was said it should be inferred that it was applied for without any real intention to use it as an indication of origin, but simply to widen the moat of protection around the existing mark with text. And that inference was said to arise from three accepted facts. The first being that the application for the wordless mark was predated by 10 years by the mark with text. The second is that the use of the wordless mark in the UK was entirely in the form of the mark with text. And the third was an acknowledgement that the wordless mark had been applied for in order to provide additional protection. Now, also challenged, my lords, were later registrations in 2002 2005, 2007, and one from 2021. Now, these were said to have been registered in bad faith because they were examples of something called evergreening, namely registration made to ensure continued protection in the light of known non-use of the earlier registration, obviously the initial one being the 1995 one, and that was an inference said to arise from the registrations covering materially the same signs and overlapping, at least partially, specifications of goods and services. And the fact of those later registrations was also said to support the inference of bad faith in the original 1995 registration, because it was suggested that they showed by their very existence a lack of belief or faith, it might be said, by Lidl, that that 1995 registration had been used, such that they needed to evergreen. Now, the judge concluded in this case that there was bad faith for all but the 2021 registration.
Can you help me on that?
Yes.
Because, certainly at the time that the matter was last before us, it was an application, and it's referred to by the judge as an application.
Yes.
Has it proceeded to registration subsequently?
I'm going to say I believe so, but I'm just double checking with those who do that. Yeah. Oh, I apologise, my lord. It has been stayed.
Right.
I apologise.
And that being so, it couldn't have been attacked anyway.
No, indeed, but there is a finding in relation.
To be sure,
Yeah.
because it was relevant in the question of the discussion about evergreening, but it wasn't formally an issue because it couldn't be.
Indeed, I'm sorry. The way I should put it is that it was part of the overall picture that was being advanced.
To be sure.
And the reason that I reference it is not only for completeness, but of course we will submit that there is some tension in the fact that that very later registration was not said to be part of this consistent pattern of behaviour, but the early ones were. Where I had got to, having summarised, as it were, the lay of the land, is to foreshadow what we ask this court to find at the end of my submissions, namely that the conclusion that the 1995, 2002 and 2005 and 2007 registrations were made in bad faith was rationally insupportable and can only have been based on an erroneous approach to the assessment of the evidence required in the case of bad faith. Now, we have in my skeleton argument suggested that perhaps the judge was led to these errors, to this conclusion, by uncertainty over the state of the law on bad faith that we hope will be resolved by the Supreme Court's judgment in Sky King, and by the content of the decision in the interim appeal, because as I know at least Lord Justice Arnold and Lord Justice Lewison are aware, we had applied to strike out the bad faith case, succeeded in front of the judge. That then came before this court and was overturned. And it is clear from her judgment that followed that she understood that the interim appeal was, the judgment in the interim appeal was the touchstone for the reasoning that she should apply. And to an extent that is obviously right, because it does set out what we accept to be the law as it stands on bad faith pending that Supreme Court judgment. But we say where she erred was to go further and to understand that what we understood Lord Justice Arnold to be saying were matters that could not be determined at an interim stage as we had urged upon her, were in fact matters that could not be determined however things then played out. In fact, we understand, and we will submit to this court, Lord Justice Arnold was quite rightly saying this is a problem about you doing this by way of strikeout. There needs to be further investigation, and we say that having done that further investigation, she should have concluded that there was.
Well, I think all we said was that if the facts are as pleaded, that is capable of amounting to bad faith.
Precisely
I don't think
so.
we said anything more than that.
Well, that is our submission, and we say that the judgment, when you look at it here, goes further than that, and indeed expressly understands herself to have been constrained in what she could do. And a particularly acute example of that is in relation to the question of evergreen, where we understand that Lord Justice Arnold was rightly pointing out that the expansion from the UK to the EU might be legitimate the first time you do it, but you will then need to have some further explanation for why there are subsequent EU registrations. But in the judgment, as we read it, the judge has simply understood Lord Justice Arnold to say expansion into the EU is no good at all and damned all by that brush. The point is more nuanced. I'm going to come to it, but my lords understand where we begin. And of course, ultimately, it doesn't matter why the judge strayed from the right path, only that we establish with you that she did, and also that, as we say, when you fully appreciate what's going on, in fact, there was ample basis for rejecting whatever implications might have arisen from the accepted facts. And therefore, at the heart of our appeal are the following propositions. The first is that the three facts that are relied on for the inference of bad faith are also consistent with good faith. So that having then found, as a matter of fact, that use had been made of the wordless mark, that it was being used in a way that served the purpose of a trademark, namely to indicate origin, that it was both inherently as well as by acquisition distinctive. Knowing that Lidl had said that it would be used when applying for the mark and that they would use it in precisely the way that the judge then held was genuine use and had served to identify the goods and services of Lidl, there was no longer an inference available, supportable in the terms in which the EU authorities set it, that the application was made in bad faith, and the conclusion therefore was rationally insupportable. We do say that as part of that, the presumption of good faith is not dispelled by the matters pleaded. They create an evidential requirement on the proprietor of the mark that has to be met, but it was met, and that in the context of an allegation of bad faith, the requirement for proving that matter lay with Tesco by reference to cogent evidence that indicated consistent indicia of bad faith. Now, my lords, the next stage in my submissions is to look at the authorities on bad faith. I'm going to do it, for understandable reasons, quite swiftly, but I think it is helpful to do so, not because my lords don't understand or know those authorities, but rather because doing so frames why we say and where we say the judge went wrong. And of course the starting point must be that judgment in the response to the appeal at the interim stage. It can be found in a number of places in the bundles, but I am going to the joint authorities at tab 23. I erred yesterday, my lords, in forgetting the problem of knowledge, and I am anxious not to err again, but by the same token I am very conscious that I am now addressing a judgment in which two of the judges present were involved, but one was not, so I hope I will get the balance right, and I have no doubt that I will be told if I'm not. My lord, Lord Justice Arnold, is giving the judgment in this decision, considering, as part of it naturally, the Court of Appeal's earlier decision in Skykick. And I begin my review of it at paragraph 15, where Lord Justice Arnold is setting out the case law on bad faith. And at paragraph 16 is reference to that Court of Appeal judgment of Sir Christopher Floyd and to the summary of the principles that was given in that case. And if I may put it this way, they are laid out along with what follows might be described as corrective commentary on Sir Christopher's own recitation of the case law. At sub 4 of the list, there is the following proposition. The concept of bad faith, so understood, relates to a subjective motivation on the part of the trademark applicant namely a dishonest intention or other sinister motive. It involves conduct which departs from accepted standards of ethical behaviour or honest commercial and business practices. Now, the point then made at 11 at the bottom here perhaps identifies the touchstone for bad faith in the context of trademark matters. Because what is referred to there is the question of whether or not the application is made in order to fulfill the functions of a trademark. And it is that, if I may put it way, qualification of what is said in form, the references to dishonesty and to commercial practice that falls below the standards of ethical behaviour, that my Lord Justice Arnold is going on to qualify and to expand upon in some of the paragraphs that follow this one.
Just a quick question at this stage. I mean, I'm sure you wouldn't dispute that the paradigm function of a trademark is to indicate origin.
Not only do sorry.
So that's obvious. We note the Court of Justice refers to functions plural,
Indeed.
as it so often does.
Yes.
Is that of any particular significance in this context?
It's not in this particular context. I mean this case. But the first point is, because one of the issues that we draw this court's attention to is that the judge had made a finding that both by its inherent nature and by the acquisition of distinctiveness through the use that was made of it in the form of the use through the mark with text, it was indeed serving to fulfill that origin identification function. Now, we will say that that has relevance in 1995 for the reasons that I drew your attention to yesterday, namely that the very use that has served to help with the acquisition of it commences before the application for the 1995 mark. But we certainly submit to you that it'll be relevant in respect of the understanding of Lidl when coming to apply for the marks in 2002, 5, 7 and 2021. And indeed we go further than that, because we say by that point there had been testing of the issue such that it was not a matter of simple belief on the part of Lidl. It was a matter that they had put forward in various official contexts and received positive confirmation that their belief was one that either an IPO or indeed a European trademark court was prepared to accept. But the reason I do draw attention to it is at this point to accept, as it were, a proposition that although at paragraph 4 we understand that bad faith is a very serious allegation, one including dishonesty, it has to nonetheless be understood by reference to dishonesty of the kind that the trademark office is concerned with. And that, as I say, is why, or not the trademark office, but is concerned with the nature of a trademark. That is why I understand my Lord Justice Arnold goes on to expand upon that.
We're going to need to get into the detail in due course,
yeah.
And I don't want to take you out of your way, but just a quick question, and maybe it's best to defer it till later. But you referred there to Lidl's belief in 1995.
Yes.
Am I right in thinking that there was no evidence from Lidl as to its belief in 1995?
We say no. We say that there was evidence. And one of the problems that has arisen here is that the judge seemed to consider that the only relevant evidence would be direct evidence as to the subjective intention from, as it were, someone qualifying as the corporate mind of Lidl. Of that, there was none for the reasons that are explained by Mr. Unterhalter, the passage of time. And as you know, my lords, one of our points here is that if it were right to say that only that kind of evidence would suffice in these circumstances, that would be to unfairly prejudice marks of greater age, marks where they have been applied for by a corporate entity who is unlikely, therefore, necessarily to have those kinds of records, and we say that that would be unfair.
So yeah. I think, if I've understood correctly, you accept no direct evidence either from a witness or in the shape of documents. But you say there's other evidence from which an inference as to Lidl's belief.
So what I'm going to show you is the response of the trademark agent from 1995 to a concern by the IPO that this mark was not registrable in the light of other marks, in the course of which the explanation they give relies upon what they understand to be the inherent distinctive character of the mark. And so in that sense, I submit that you do have direct evidence that here Lidl's agents understood that the mark was itself inherently distinctive and therefore worthy of protection because capable of indicating origin for the goods and services registered. Now, there is then another piece of evidence, this in time in the form of an undertaking that was given in order to overcome an objection by Osmeroid to the registration of the mark. And there, the undertaking is making clear that Lidl understand that they will be using the mark, but also that they will be using it in the form of the mark with text, and that that therefore aligns with all of the subsequent evidence and findings of the judge, namely, we said at the time that we're going to use it, and we said we're going to use it in the way that the judge has subsequently found is good use, in the sense that trademark use was required to be good use, namely genuine use for the purposes of creating or maintaining a market under this sign for the services or goods for which it's registered. So in that sense, my lords, we say there is contemporaneous evidence that goes to precisely the issue raised by number 4, what was the subjective motivation on the part of the trademark owner. We say part of the error that was made by the judge is that she dismissed that evidence, either, although it's not entirely clear why, either because she assumed that only direct evidence of the kind that we've just talked about, namely someone from the corporate mind of Lidl who knew at the time, was good enough. If so, we say wrong, clearly too demanding. Or because she dismissed that, as she appears to have done in relation to the statement of intention to use, as mere trademark minutiae, having no bearing in the real world.
Well, she did find, didn't she, that Lidl has never used the wordless mark in the form in which it's registered.
Indeed, but as I think a point taken on appeal, and this issue was, that was accepted. So that was the starting point. So it's a finding that we have done what we admitted we were doing didn't advance matters anymore. What lay uncertain at that stage, and what my Lord Justice Arnold, among other things, I accept, was saying needed to be investigated and therefore could not be allowed to pass as a matter of interim dismissal, was whether or not we were right to say that that use was good enough. And where we say that the judge went wrong, why we are actually slightly surprised to be in this position, is that having found that we had made use of precisely the kind we say, she should have drawn all of the threads together. The potential for it to indicate bad faith at that point had been answered by the best evidence that was available to us, and that meant that there was no longer cogent, certainly not consistent indicia of bad faith, because everything that followed from that was actually consistent with good faith. Now, there is, of course, at the heart of this, an issue, which is whether or not there is a fundamental problem with marks that are themselves subsumed within another mark. On that, where we had pressed at first instance was the idea that because that was consistent with good faith, for reasons that I'm sure my Lord Justice Arnold is aware of, but I'm certainly going to expand upon, it couldn't therefore be a sufficient basis as a matter of pleading just to have pleaded something that was, we said, consistent with good faith. The answer comes back, well, no, that's not right, because it raises at least a question that must be answered. And that is the state of the law. Certainly it is the state of the play in this particular case. It had to be answered, but we did. And obviously one of the points that's made in this judgment, I've got to come to it, is that there are a couple of cases about the defensive marks and the nature of them and how that played out. And I want to address that because we say that they can be distinguished in how they played out from what happened here, but that actually the judge appears to have thought that my Lord, or possibly the judge appears to have thought that my Lord Justice Arnold was saying you cannot have a mark that is subsumed within a mark, whereas what I think, what I submit he was saying, find out, is what you cannot have is a defensive mark, and a potential indication of a defensive mark is that it is one that is subsumed within another mark. My Lord's questions actually allowed me to advance some of what I was going to say later, but can I return to where I was in this particular judgment in order to keep with the idea of setting out the principles. So, having looked at 4 and 11, the next one that I draw to your attention is 6. Notwithstanding that it is within the context of trademarks, it is nonetheless a very serious allegation. And it is one that is therefore, perhaps unsurprisingly, for the party alleging to prove, with good faith being presumed until the contrary is proven. And we do point to a distinction between a requirement for the presumption of good faith to remain until proven to the contrary, with an evidential burden to answer something that may indicate bad faith. We say that that presumption of good faith remains until met by proving to the contrary. Now at 7, we suggest, and this is an expansion of the submission I've just made, is a point akin to that found in the context of copyright copying. At 7, it's explained that where the court or tribunal finds the objective circumstances of a particular case raise a rebuttable presumption of lack of good faith, it is for the applicant to provide a plausible explanation of the objectives and commercial logic pursued by the application. And we say that this is not something that results either in the shifting of the legal burden of proof or in the removal of the presumption of good faith, that being an aspect, we say, of the nature of the allegation in the first place. But it does create a question of a shift in the evidential burden, because at that point there is a need for the applicant to justify the matters that might be said to be capable of leading to an inference of bad faith. But that ultimately, as it is in the context of copying, it is a question that remains for the person alleging bad faith to prove on the basis of all of the evidence. And it is for that reason that you have the point made at 10, namely that even the existence of objective indicia pointing towards bad faith may not exclude the pursuit of a legitimate objective, such as the excluding of copyists. That is effectively a way of saying you've still got to look at everything in the round. And indeed, we also submit that it is reflected in my Lord Justice Arnold's judgment in Walton, which he quotes at paragraph 23 in this judgment, and is extremely well known, but also, if I may say so, is a statement that applies to all allegations of this kind, namely that by the nature of the seriousness of the allegation, there is an inherent implausibility that a party will have behaved.
No. That proposition, which was enunciated in, I think it was Re-H, was firmly rebutted by the Supreme Court in, I think it was Re-B, or maybe it was the other way around.
I do understand the point my Lord's making. I'm not suggesting that it changes the burden.
It's not a question of probability, it's a question of cogency.
My Lord, that is the point I'm trying to make. I'm certainly not suggesting that it's changed the burden of proof. What I am advocating is that where one has a starting point for this kind of serious allegation, as my Lord has said in Walton, as has been repeated in 23, the presumption is of good faith, because it's a serious allegation, must be distinctly pleaded and proved by Tesco, and the standard of proof remains the balance of probabilities, but cogent evidence is required. And of course, in saying that, it reflects only what was said in the Court of Justice in Skykick, namely that there needs to be consistent indicia of bad faith. Now, my Lords, one of the references that's been given here is to the Hasbro case, and because, as I've explained at paragraph 21 of our skeleton on this appeal, we say that forms part of the erroneous approach that was taken by the judge, can I just quickly take you to Hasbro so that you can see the particular paragraphs that are in issue in context, and that is to be found in the Joint Authorities bundle at page 474, which is behind tab 16. The registration in, sorry, my Lord, the registration in this case was for the famous sign Monopoly, and the paragraphs that are referred to when summarising the principles are to be found at page 477, and they have been sidelined 42 through to 44. And the reason I'm taking you to the specifics of what is said here is only to emphasise that the judgment here is making clear that it is the applicant for a declaration of invalidity to prove the circumstances which make it possible to conclude that an application for registration was filed in bad faith, good faith being presumed until proven otherwise. But that, as they explain then at 43, where the intellectual property offices find that the objective circumstances of the particular case relied on by the applicant may lead to the rebuttal of the presumption of good faith, which the proprietor of the mark at issue enjoys when he or she files the application for registration of the mark, it is for the proprietor of that mark to provide plausible explanations regarding the objectives and commercial logic pursued by the application for registration of that mark. So an evidential burden then arises, and it is, we submit, an evidential burden to provide plausible explanations regarding the objectives and commercial logic.
Well, they're much more specific in 44, aren't they? The proprietor is best placed to provide a UIPO with information regarding his or her intentions at the time of applying for registration.
Absolutely. And that is why there is the evidential burden shifting, because enough has been done to require them to simply to show what they have. But that cannot interfere with the further question of what are they in a position to put before you. And of course my lords know that one of the points we make in our skeleton argument is that it is a principle that you must be tested by reference to the evidence that you are capable of bringing forward. And where you are dealing with a mark that was applied for in 1995 in a corporate setting, that must be taken into account. And to the extent that the judge appears to have understood this to be a requirement for direct evidence from the person who did the application, we say she erred. It cannot be a principle that is necessary. It would, as we say, unfairly prejudice certain categories of applicants against others. And we say, moreover, it's not necessary to read it in that way to understand both what is being said here in Hasbro and why my Lord Justice Arnold and Lord Justice Lewison said that you can't dispose of it at the interim stage without having asked us to show, as it were, the best available evidence that we've got to give to the court. My Lord, I was going to take you to a couple more things in Hasbro, but it might be a convenient moment to break.
All right, fine. How are we doing for time?
I was expecting to start a little earlier, but I still anticipate being finished well before the end of the afternoon, so that my learned friend will be able to make his points and I'll be able to make my reply. We'll be done today.
Good. All right. 2 o'clock.